Hey, y'all, and welcome to tonight's live stream. Well, we are back on the Karen Reed case. Today, there was an extremely important hearing in her case. And you may think to yourself, oh, well, it's trial that really matters. What happens when the jury's there? And it's true that that's incredibly important. But the decisions that are made right now are the ones that are going to make what the jury hears what it is. And so if the judge decides to rule in certain evidence or to allow the Commonwealth or Karen Reed to see the evidence, or if she excludes it, these make all the difference in the case. And so we're going to be looking at what the court did today, what the arguments were. There weren't direct rulings, but the court gave us some pretty big hints about where she's going. First of all, the Commonwealth is trying to get its hands on the notes that were taken by a Boston Magazine reporter when she interviewed Karen Reed. Now, clearly, the Commonwealth and the judge think there's something really good for the Commonwealth in those notes and that's bad for Karen Reed. We don't know exactly what they are. The judge, however, has seen them and said for sure that there are things in there that the Commonwealth would want to see. We'll listen to what she had to say tonight during the live stream. So what are these notes and what's in them that could help the Commonwealth, that could hurt Karen Reed? We got a little bit of a window into that today and what the judge said. And we still don't know the final ruling on whether or not the Commonwealth will get to see these notes and maybe use them at the second trial. But we will get to that tonight. Secondly, huge issue today was the Commonwealth is working overtime to try to keep out that damning search by Jennifer McCabe, Haas Lawn to Die in Cold. They are trying to exclude the opinion of the defense expert, Richard Green, who says that Jen McCabe typed that search into her phone at 2:27 a.m., which should have been before anyone knew John O'Keefe was dying in the snow outside the home where Jennifer McCabe was attending a party. But the biggest motion of all is yet to come. Earlier this week, Karen Reed's defense dropped a huge hint about a motion to dismiss the entire case that could change everything for Karen Reed. We learned some more about that, and we'll cover that too. Special shout out to the first five in the chat tonight: Beth A., Michael Lalonde, Shira Sheena, Jebby Camphor, and Lila L. And because I wasn't sure if some of those were from other nights too, also special shout out to Maria Z and KS. So let's dive in and find out more about what happened today. Now, what are these secret reporter notes? Karen Reed gave an interview to Gretchen Voss. She's a reporter for Boston Magazine, and Voss wrote an article. That's public. The Commonwealth has that article, but she also had audio tape from the interview. Now the Commonwealth also has that. But what the Commonwealth does not yet have is the notes that Voss took when she interviewed Karen Reed. They got part of the notes, but some parts were redacted or cut out. And so the new Commonwealth attorney, the acting prosecutor for the case, has asked to see all the notes, not just the redacted ones, not with little excerpts taken out, but the whole thing. So here's why the Commonwealth does not already have these notes. The reporter is arguing that these notes should be kept confidential. She says she was talking to Karen Reed off the record and told her that she wouldn't make what Karen Reed told her public. There were parts that were in the article that were on the record, but this part was off the record. It wasn't supposed to be for public disclosure. Now, in many states, there would not really be a question about this. The reporter's notes would be confidential because many states have a reporter's privilege, but Massachusetts does not. Let's take a look at, this will be for next. Let me hold on to that for just a second. So there is no privilege for news reporters under Massachusetts law, no straight up privilege. But the magazine does argue that there's a balancing test, that there's a state, you have to take the state's need for it or whatever party is trying to get it. How much do they really need that versus how much does a reporter need to keep this private? How important is the public interest in making sure reporters can have confidential sources? So, of course, all of the players here should know the ground rules in Massachusetts, because the reporter obviously would know. She works for Boston Magazine and really shouldn't have taken notes that she didn't want disclosed because of this concern. Now, Karen Reed, of course, was working with attorneys at the time, so shouldn't also have been surprised about what happened. So in December, Judge Canoni ruled on this issue. She said, here's what she said. She said she looked at them, and some of these things were really important. What she said was that those redacted materials suggest that the account she, meaning Karen Reed, gave to Boston Magazine may have differed in certain respects from expected evidence at trial and from other accounts she has given. However, the redactions prevent the Commonwealth from fully understanding the defendant's statements. And we got a little more than that today, a little more of a hint about what exactly is in those notes that would be really problematic for Karen Reed. So notice that one of the things that she talks about is plural. Well, let's go ahead and watch a little bit of what happened today at the hearing. This is the attorney for Miss Voss, Gretchen Voss, the reporter, arguing to the court that she should not have to turn over her notes to the Commonwealth.
To the court all of the responsive materials, the unredacted tapes and the text messages that involved on the record communications by Voss with defendant Reed. I'm here today to implore the court to reconsider that part of its ruling, but also would require Gretchen Voss to turn over handwritten notes of an interview with Reed that the parties had agreed in advance would be off the record.
So Gretchen Voss says her ability to be a reporter is at stake here. That particularly since she told Karen Reed that this interview would be off the record, she needs to follow through with that commitment to Karen Reed. She filed an affidavit, Gretchen Voss did, with the court, and here's what she told the court in her affidavit.
Like most investigative reporters, I frequently agree with sources, including keeping my word on this is critical to maintaining credibility and trust, and thus maintain source relationships while not interfering with the flow of important information to the public.
Her attorney argued that the order that Judge Canoni that made her turn over all these notes, or would make her turn over all these notes, was asking Gretchen Voss to make an impossible choice, because it was going to be a choice she was going to have to make between obeying the court order and keeping her promise to Karen Reed. And the attorney for Gretchen Voss said, look, she doesn't even need to make that choice. Here's his argument.
The court's December 5 order forces Gretchen Voss to choose between either keeping her word to her source and thereby violating the court's command, or else obeying the court's order and establishing herself as a reporter whose word cannot be trusted. It's an unnecessary choice to present to her, at least on the facts of this case. The court shouldn't insist on publication of the off-the-record notes because the Commonwealth has failed to meet its burden, and also because requiring Voss to turn over these confidential notes would damage First Amendment interests more than it would benefit the public in achieving justice for this criminal defendant. The moving party has to show, number one, that the documents are evidentially relevant, number two, that they're not otherwise procurable reasonably in advance of trial by the exercise of due diligence, number three, that the party cannot properly prepare for trial without such production and inspection in advance of trial, and that the failure to obtain such inspection may tend unreasonably to delay the trial, and number four, that the application is made in good faith and, critically, is not intended as a general fishing expedition.
So the attorney for Voss is arguing this isn't something where there's no privilege at all, excuse me, in Massachusetts, and therefore you just automatically hand over notes as a reporter. He's saying it's different from that. There still has to be some kind of reason for it, and you have to, the Commonwealth bears some proving here. They're going to have to actually prove that they need these documents, that they couldn't get them otherwise, and they're going to have to show that to the court. And he argues that the Commonwealth just can't do that. The Commonwealth does not truly need these notes. Here's what he said next.
In this case, however, there's been no showing that the handwritten notes contain admissible evidence. When you apply it to the facts of this case, there is uncertain relevancy of the information in the off-the-record notes. Not seeing them, it's hard to know whether they're relevant or not.
So that's a little bit of a circular argument that you hear him making there, because he's saying you have to see the documents to know that they're relevant, but you have to prove they're relevant without seeing the documents, which would make it pretty impossible to ever get the notes from a reporter. So the judge does not agree with him. The judge doesn't see it that way. We'll get to that in just a minute. I'm going to play you what she had to say about this. But let's keep going on this. Her attorney argues that since she was talking to Karen Reed off the record, since Gretchen Voss was talking to Karen Reed off the record, Gretchen Voss's notes deserve some extra heightened protection. It's important that these be kept confidential, and it should be even harder for the state to get to see these.
The balancing test in the First Amendment interests here too. The December 5 order ignores the on-the-record, off-the-record distinction. That distinction matters. Confidential information is extra protection because, as stated in LaRouche, disclosure of such confidential material would clearly jeopardize the ability of journalists and the media to gather information, and therefore would have a chilling effect on speech. The legal and administrative costs of battling or complying will chip away at the precarious resources of much of the media. Easy allowance of media subpoenas also risks leading to a decline in investigative journalism altogether. This is the most expensive kind of journalism. Reporting, writing, editing, and fact-checking investigations take significant time and resources. Magazines like Boston Magazine will not be able to risk becoming enmeshed in situations such as this one, with the result that they shy away from controversial topics, and the flow of vigorous reporting will suffer. We'll feel we have no choice but to select tamer, less controversial topics for our coverage. Another concern expressed by Editor Vogel is that reporters will be incentivized to destroy notes and interview tapes after a story is published.
So he's making great arguments here, but I think the judge is does think that these are more arguments that need to be made to the legislature. The legislature could have done what other states did and could have made a reporter's privilege, but did not. And so while there are some strong arguments that he's making, such as you're going to judge, if you do this, you're going to discourage some of the most important reporting of all. And that's this investigative journalism like she's doing, because that's hard. It's time intensive. It requires a lot of fact checking, and you don't want to discourage that from the media. And he's also saying it might force people who had information, could give tips to the media, to hold back for fear that at some point it might get known. The reporter might have to turn this information over to somebody else. So, and he even argues that it could turn around what topics get covered. Maybe certain topics would be covered that would be less expensive or easier, but when it came to the really hard ones, they would shy away from that. And that is exactly what we don't want in terms of how the media is handled. That's so important. I'm going to talk for just a minute in a second about what the whole issue of media and media in cases. So we'll get to that. I do want you to hear, though, what the judge seems to be kind of leaning toward.
I think in this criminal case, the Commonwealth has proven that any material that reflects or relates to communication with the defendant must be turned over. So what I'm going to propose is that I do believe that there's some material in these notes that I don't need to provide to the Commonwealth, that I don't need to order be provided to the Commonwealth, that are just sort of observations. I have the notes, and you can propose redactions to things that are not reflective of communication with the defendant. Observations, things of that nature.
So I do want to say too, I know that Judge Canoni has gotten a lot of negative talk in social media, on YouTube. And I realize that a lot of people feel strongly that she has not been as good a judge as they would like to have seen in this case, and maybe been unfair to Karen Reed. But I want to say just the fact that she's actually read this entire document, she's read through all of the notes, that's actually pretty unusual for a judge. They might refer this to a magistrate, but to actually have personally read it all and have some personal opinions about what would be relevant and what wouldn't, that's pretty impressive work, and is what you want a judge to be doing. It's ideal for a judge to be doing that. So she's saying she thinks that the Commonwealth ought to get to see anything that involves communication with Karen Reed. And she's going to give them a chance, give the newspaper or the magazine a chance to look through these notes and point out specific things where this is not a communication with Karen Reed. This is maybe just an observation that the reporter had, and that's not the same. But anything that was communicated back and forth, that's what the Commonwealth ought to be able to see. And so the judge is saying, this is where I'm headed. This is where I'm headed toward doing it. Now, the attorney does not give up. He keeps going with his argument.
I went through the notes with this question in mind. Can you separate the impressions and integrity of the thoughts of the writer from the statements of the interviewee? And I don't think they're distinguishable. I think they're all melded together in one. And frankly, it's her selection of questions that she asks Ms. Reed that gives an eye hole into what her thoughts are about the case. She shouldn't have to produce that work product.
He's using language that attorneys will recognize. In the legal field, we talk about something called work product, attorney work product. And what we're talking about is when an attorney is working on a case, there will be things that notes you'll take, interviews you'll do, things where you're working and thinking about the case. All of that is considered work product, and the other side doesn't get to see that. It's confidential to you as the attorney handling, litigating the case. So he's using that kind of language and saying there ought to be work product of a reporter too. And the reporter, every time she asks a question, is sort of revealing what she was thinking. Because if she asks, well, tell me about this, she's clearly thinking about that very issue. She's trying to raise that issue. She thinks it might be important. And so he's saying we ought to treat this kind of like we do with lawyers, which is anytime the person, it could reveal what the reporter is thinking, we ought to consider that confidential. Now, Judge Canoni said she would take it under advisement, but at this point there was, I think it's pretty clear what direction she's headed. I think she is headed toward that she is going to allow these notes to be turned over to the Commonwealth. What exactly is in them, we don't know for sure. There was a hint from Judge Canoni that these include information about drinking and alcohol with Karen Reed. There was a hint about that, but we don't know exactly. Of course, that was a huge issue in the first trial. In the first trial, Karen Reed said that when she got to the Waterfall restaurant, she drank nothing but water. She said, I wasn't drunk when I dropped John O'Keefe off in front of the home and when I then headed back home. Obviously, that would mean it would be unlikely that she would back into her boyfriend as he was walking into the house, knock him down in the snow, and that he died that way. Karen Reed's theory, of course, is she had nothing to do with that. He went on into the party after she dropped him off into the home where the party was being held. They killed him, or very near did, and then put him out in the snow, let him die there as the snow fell on him. that was her argument in trial number one. And so we'll be seeing that again. But the argument that she had that she wasn't intoxicated might be changed if, in fact, she told the reporter that she had been drinking. The Commonwealth argued she'd had multiple shots throughout the night and that she continued drinking at the Waterfall Bar. They counted up, I think it was 11 shots, some crazy large amount of drinking. And they said that's how much she did. If that's what Karen Reed told the reporter, it could make a difference at trial because the jury might then be forced to consider whether or not she, in fact, was drunk at the time that she hit John O'Keefe. Of course, she argues she didn't hit him at all, but that could be the kind of argument we would see next time if these reporters' notes come in. We don't know what all is included. We just know a little bit about it. So I want to talk for just a minute about transparency and interviewing with the media. I've been a real advocate for the idea that lawyers need to be more open with the media, that the old method of doing things where the defendant was really in favor of absolutely nothing being said to the media so that nothing could possibly prejudice the potential jurors, that's out, that's old. Because what happens now is the prosecution issues a gigantic, they hold a press conference, they issue a statement, they usually have a very detailed initial pleading, whether it be a complaint or an indictment, whatever they file, they have this very detailed pleading, and that's all in the public. And only then does the Iron Curtain slam down around the case, and no one else is allowed to talk about the case. At that point, the defendant falls further and further and further behind because all that's in the public, all that anyone is talking about is the prosecution's case. Nothing about the defendant's case is even available to the public. And so they aren't talking about it. It becomes the prosecution's case all the way up until the time of trial. And I think that that's dangerous and unfortunate for defendants. In this particular case, we are seeing, though, there is a negative, a dangerous side to this. Karen Reed, I am convinced, would be in jail right this minute if she had not gone very public with her battle to prove that she was not guilty. She has been very open. She has done interviews. She's talked to podcasters. She's talked to people on YouTube. She's been very clear she is not guilty, and she has not been afraid to say that publicly and to be clear about that. If she had not done that, I am convinced she would be in prison right now, convicted. As it is, though, there is a dark side to this. There is always risk that someone will say something that contradicts something they say later. We do that all the time when we talk, even when we aren't lying intentionally, even just because that's the way people interact and that's the way people talk. So there can be a cost of that. I still think it was a wise choice for her because I don't think she really had a choice here, but it could come with a cost, and the cost might be right here where the reporter's notes get turned over. We will find that out soon enough. Mama Pinks, thank you for letting me know. Donna E., congratulations, cancer-free. That is so incredibly awesome. We are all so, so happy for you. That is absolutely wonderful. Definitely ring that bell. That is fantastic news. Thank you for sharing that with us. And thank you, Mama Pinks, for bringing that to my attention. And Michael Lalonde pointing out that I'm wearing red, and I do love red. Thank you very much, Michael. All right. So the next issue that was extremely important and that was important in terms of what got decided at the hearing today, or what got argued at the hearing today. Let me put it that way. The Commonwealth has filed a motion to exclude Richard Green's what they call debunked opinions. He is one of the experts for the defense and an incredibly important expert for the defense because he is the expert who looked at the Celebrite data and said, you know, Jennifer McCabe searched Haslam to die in cold at 2:27 a.m. in the morning. And if she searched that at 2:27 a.m. in the morning, how did she have any clue that John O'Keefe was dying in the cold? Why would she search that? Because John O'Keefe wasn't found until the next morning when Karen Reed and Jim McCabe drove up and saw him lying in the front yard. That was supposedly the first time anyone knew that John O'Keefe was out there in the snow. So if she was typing in Hossalon to dying cold, then why? What would be her reasoning for doing that? Unless it fits with the defense theory that Jim McCabe was in on a conspiracy within the house there, that they had attacked and hurt John O'Keefe. And so they dragged him out in the snow, left him there as the snow fell on him that night, because they were trying to frame Karen Reed, or at least get him out of the house so that they didn't have direct responsibility. So Green's testimony was super important. During trial last time, there was counter testimony. We actually had a Celebrite employee come and say, yeah, we've had to revise our programming. While before we had said that there was this 2:20, before it did look like 2:27 a.m. was when this was typed in, but there was a glitch in our programming, and the way it works was, we fixed it now, but the way it did work was, if you opened up a window on your phone, then if you went back into that same window and you typed in a new search, it registered as the time you opened the window, I think. I may not have that quite right, but I think that's pretty close. And so he said, look, Green said this was at 2:27 a.m. in the morning, and that was explosive because it was not something that could have been done unless the defense theory was correct. And he said it was intentionally deleted. So now the Commonwealth is saying, look, we all have information now from Celebrite that says this is false. It's no longer true. And since it's no longer true, Green can't say this anymore. You should keep him from saying that this was a search done at 2:27 a.m. and you should keep him from saying it was intentionally deleted. Now, he says that, I mean Green says that he not only looked at Celebrite, he also ran this through some other programs. And these other programs show that it was actually 2:27 a.m. They still say that. So even though Celebrite updated its programming, it's still 2:27 a.m. on these other programs. So he believes he's still right. Celebrite got their update wrong. That's what I believe he'll say when it comes time for trial. So the argument was over the Commonwealth's desire to keep this out entirely and to say Green's not allowed to testify about this. And the defense side saying, look, this is still a valid opinion. The fact that you don't agree with it or your experts don't agree with it doesn't mean that it's no good. So let's take a listen to what was said at the hearing about this.
We filed a motion to exclude Mr. Green as a witness regarding 2 points. The first is a claim that a witness's phone made a search for a phrase to the effect of how long to die in the cold at 2:27 a.m. And secondly, to exclude an opinion that there was some type of intentional deletion of that entry.
I'm going to go ahead and stop it right there to kind of explain to you what the next little clip is. So one of the things that the Commonwealth talked about is the fact that there were two different affidavits. In other words, initially Green filed one affidavit and now he's updated it and has a new affidavit. But in this argument, the Commonwealth picked out some very, I think, pretty small differences between them and really spent some time talking about those. I'm curious whether you think these are all that important.
His affidavit is an absence of methodology. Mr. Green has filed two affidavits in this case. They are very similar, but there are very significant changes to those affidavits. On number 3, he changes his characterization of what his profession is. He originally calls himself a forensic technician, and then the updated affidavit cites that he's a computer network technician. Now that is odd because usually a profession in this simple explanation of what he does stands out. Number
That seems so kind of minor to me, whether he's a forensic technician or a computer network technician. I don't know. That doesn't seem all that wildly different to me. But I'd be
9
curious. Maybe you disagree.
talks about the download as a full file system extraction, then change to an Apple iOS full file system. My point is that when you look, this isn't simply misspellings or poor grammar. There are terms of art that are wrong between the affidavits or changed. When you're using the terminology of an item that is a forensic tool, such as gray key, it is spelled wrong throughout the affidavit. When we look at Mr. Green's affidavit, it is not that of a forensic examiner, it's that of an advocate for the defense. It is a very dangerous affidavit to simply...
We'll stop there. I see, first of all, Michael is saying he wears a lot of green. So as Mr. Green probably does as well. Thank you, Michael. And Michelle is saying that the judges ruled that the Commonwealth does not get Gretchen Voss's notes. That might be, I just did a quick search and it's not coming up for me yet, but Michelle may well have some additional information. So that would be a significant blow to the Commonwealth, I think, because she's hinted that there's some information in there that would be really helpful to them. And if they don't get to see it, obviously that's for them going to be a disappointment. So let's keep going. Thank you for your super chat, Michelle. I appreciate it. And also the information. We'll keep tracking that and try to follow that. So to me, the kinds of things he was talking about were just kind of small, like that he called it a full file system extraction, then an Apple iOS full file system. I mean, to me, those seem small. That could be that these are super important if you're in the field, but they didn't seem all that important to me, which I think kind of diminished the Commonwealth's overarching argument, because this, I think, is what really bothers the Commonwealth.
Make assaultive comments that a user did something, purposely deleted a very important phrase, how long to die in the cold, without any forensic data or evaluation or validation. Suggesting, but never proving, never providing fact, that there was some type of manipulation or tampering with evidence. And so the defense, without having an opportunity for Mr. Green prior to trial stand behind these statements under oath, would like him simply to come before the jury, make these salacious comments, and then leave it to the government to knock it down. That might be a common approach reviewing the transcripts of this case, but the Commonwealth does not intend to simply let evidence come in that's not qualified, that's not factually sound, and then go knock down glass houses. That is not the approach the government's going to take to this case.
And throughout the hearings, since he's taken over the case, he's tried to make it really clear that he wants things to be different, but he is having a very hard time moving things in a different direction, making the case turn out differently. Now, I will say this, anytime you retry a case, it's really different. No two cases try exactly the same. If you get a case reversed on appeal and you try it again, it's not the same case. You have to be prepared for a lot of new things. But so far, he hasn't really been able to make any serious scores on making the case different. That's what he's trying to do, shake it up, change what happened. And so far, it's not working. I am so intrigued. I'm still searching to see whether or not there's actually been a ruling on the Gretchen Voss note so I can confirm that. That'd be really exciting if it happened while we were on our live. So I'm trying to confirm what Michelle is telling us she has already found out. So if I do, I'll let you know. All right. So he is particularly galled, I think, the prosecutor, that Green actually just called customer service to ask him a question. He seems to think that this is really low end. If you just call customer service and ask them, it's like cheating. You should be an expert and you shouldn't have to call customer service.
And the science and data is clear. Instead of doing validation or testing, relying on Cellbrite, what Mr. Green has done in section number 13 of his affidavit is step aside from methodology, and instead he cites that he called Cellbrite technical service. Now, this is the forensic examiner who is supposed to go through the process, and yet he defers it to technical support of Selbright.
Now, the expert did not do any testing that would show what he is trying to say, which is that if you open up a screen at 2:27 and then you go back into that same screen at 6:05 or 6:10 or whatever it was, then it will show as 2:27. He hasn't done testing to do that. He said instead, he says, well, someone could have manipulated the cell phone, could have deleted the message. And the prosecutor is saying, look, you can't just say that. The standard is to a reasonable degree of scientific certainty. Could have doesn't meet that standard.
It is suggesting that a witness with no other evidence whatsoever was involved in a conspiracy to murder somebody. That's the implication that he wants the jury to be confused by. Otherwise, there'd be no other reason to make the suggestion. That is an extraordinarily harsh claim when you don't have any facts to back it up.
So when you get down to it, the real objection that the Commonwealth has is that Green is making an argument for the defense that the Commonwealth thinks is wrong. But that's not what a Daubert hearing is supposed to be. But here they are making this argument.
So what arises from this subterfuge is that Mr. Green is really just a vessel, or an attempted vessel, for the defense, third-party culprit defense, in addition to the fact that he wants to now appear as advocate for the defense and accuse everybody and anybody without articulating who, just anybody other than the defense.
So what the prosecution is asking for is a hearing where they can get the judge to say, Green either can't be an expert, or at least they specifically ask that he not be allowed to say that this Haslong to die in cold was done at 2:27 a.m., that he can't say that they want it limited and some confines put around it, that he's not allowed to talk about that at trial. And they want to have a hearing to do that, or at least they're willing to have a hearing. But the defense said, look, yeah, we have hearings. We have hearings where we look at whether or not an expert is really qualified to talk about something. But we do that when there is a reason to believe the person isn't qualified. We don't do that because we don't like their opinion. We do that because they literally just could not give a reasonable opinion to the jury because they don't have the qualifications for that. Here's the defense making that argument.
Mr. Green testified at the first trial. He testified without objections as to his qualifications. He testified without objections to his methodology.
So they're arguing, look, he's already been accepted as an expert. If he was an expert at the first trial, what has happened that would make him unexpert? How would that even work?
Mr. Green did more, had a more encompassing and comprehensive review than any of the witnesses here. And back to Exhibit 1, he did 2 more steps in his methodology than everyone else. So 1 through 5 of the methodology, everybody did. 6 is analyze overall user activity, artifacts of interest, timelines of interest, and anomalies such as deleted data. 7, reporting as appropriate pertinent artifacts, other artifacts. For this motion, Mr. Green did 6 and 7, and no other witness did that. The issue in this case as to whose interpretation is correct is an opinion issue. It is not a methodology issue. I just don't understand how it can be stated that there's no methodology stated. Not only does Mr. Green state it, we prove undisputed that everybody agrees this is what the methodology is. And that is what is so flummoxing as to why we're even here, because the methodology is agreed upon. What is disputed, Your Honor, is what are the opinions from when you apply the methodology and you apply these tools. What was said, it's alleged that Mr. Green has reckless opinions. My point exactly, take away the reckless. They're going after his opinions and it's been stated now by the Commonwealth itself. It's the opinions, and those are not proper for a Daubert hearing.
Now, he's pretty much right about that. That's that it's more, a Daubert hearing is supposed to look at whether the witness is qualified. It does look at whether or not there's valid underpinnings to the opinions that the person's giving. But I mean, he does have a point there, I think. Here's what I'm guessing, and we don't have enough explanation to understand exactly what it is that Green is going to argue yet, but or at least I don't. I don't have enough background to say. But I think essentially what the prosecution is going to argue about what Green says is that Green looked at a bunch of programs, other programs that are derived from or came from the Celebrite. And so those haven't been updated or changed or improved yet. So when he looked at the other ones, of course, they still said 227 because they hadn't incorporated the change from the Celebrite one. Celebrite's kind of the granddaddy of them all, the big one. Now, I don't know for sure that's what he'll argue, but that's kind of how I envision it going when we get to trial. And so they're going to say, look, that's frozen in time. And it's not, of course, changing and updating with Celebrite. They haven't done that yet. That isn't how those other programs work. So they believe that the 227 is just fake. It's just literally incorrect, that it's proven and demonstrably incorrect. The judge didn't seem to be super interested in this, but we did get some information that the Commonwealth is apparently going to do some testing. They are going to try to show that when you go, that at least under the old Celebrite version, when you opened up the window when you didn't close the window and you went back in and searched, it will show the original time, not the new time.
Because if he actually does the testing and takes a phone and tested his hypothesis, he would dispel his own hypothesis. And if he doesn't do that, we'll do that for him.
I think the judge is unlikely to grant this for them. And here's why I think that.
You're not going to hear this motion today because I didn't have the opposition.
Sorry. Moving on. So I think the judge is not going to, because she pretty much just said, yeah, I think that this is going to be, she just seemed to imply that she didn't think it had a lot of merit. I don't think she's going to keep out Mr. Green's opinion entirely. Now, whether or not the Commonwealth can come up with a good, understandable explanation of why it's not the same, we'll have to find that out. I'll be very interested to hear exactly what their explanation is about why they believe the opinion is completely false and what they believe why his new opinions are still completely false. I'll be interested to hear that. So then we got to we didn't hear a third motion today, but there was discussion about a potential motion to dismiss. The defense had filed a motion to get their expert travel fees. And in a footnote, which the court clearly locked onto, noticed in that footnote, they referred to whether or not they would be filing a motion to dismiss related to the Sallyport video. You can remember that's the video of Karen Reed's car in what's called a Sallyport there at the police station. And there is a gap. And there were two issues. One was the jury was shown an inverted version of it. But then there was a second issue, which was there were gaps, missing portions of the videotape that should have existed to show Karen Reed's vehicle. And Karen Reed's team says, well, it was during those times that there was interference with her car where somebody maybe broke or worked on her taillight and intentionally set her up. So they apparently are going to ask for a dismissal of the entire case against her. She would completely walk away from the case. So there was tons of discussion today about this. The judge very much wanted them to file this now. Let's do this right this minute, as soon as possible. She said, I'm not going to hear it today, but we need to get moving on.
One of the things that I'm hoping you can tell me before we hear this, all right, there are a couple of things. Let me just, in this motion, there's a footnote that references, so this motion from the Commonwealth was filed, from the defendant was filed on January 23rd. So more than a week ago, and the motion, I believe, is a footnote that highlights a pending motion to dismiss. I need that motion to dismiss. We need to get this moving. When will that, well, I'd like that filed next week so we can hear it next week.
The reason that we haven't finalized it, the reason we haven't put the full contours on that motion is because we haven't received all the discovery. And I think it would be premature for us to figure out exactly what the parameters of our motion to dismiss are until we know exactly what the Commonwealth is putting in front of us in terms of the second trial. But as soon as we get that, we think that we have the grounds to bring that motion relatively quickly thereafter.
So you expect to have everything to the defendants by Wednesday?
I do, and really what's missing is a report from a neurologist.
We'll go ahead and stop there because I think that pretty much tells us what we need to know. The judge gave the defense a deadline of about a week and a half from now, of Monday or Tuesday, not this week, but the next, to go ahead and file this motion to dismiss. That will be absolutely enormous. We'll definitely cover it here on the channel. That's a motion that could change absolutely everything for Karen Reed and for the entire case if they were to win their request to get the case dismissed. I believe they'll be doing it on the grounds that they think that this evidence should have been available to them, was destroyed by a party who should have retained it, and therefore the case reason that the entire case should be dismissed against her. So let's do a few questions. And if you have question marks at the beginning, that'll help me spot your questions over here in the chat. And I would appreciate that. So as far as what the court will do on that, I mean, my guess is the court is not going to dismiss the case against Karen Reed, but I'm very curious to see what exactly there is going to, what the court will do based on what they argue. We don't have their motion yet, but I think it'll be really interesting when we do. All right, so I'm looking for y'all have no questions. I see one about the color of my eyes. That is not case related. We need to be case related. However, I will say this. One thing that drives me nuts, the Canva, which is how I make my thumbnails, and they have this way that you can upgrade a picture. It makes it look kind of more detailed. It looks like you took it with a better camera, basically. And it changes the color of my eyes. I find that really insulting. It's like, oh, here's an upgrade for you. If only your eyes were a different color. Like, well, I'm kind of offended by that. I think my eyes are just fine. Thank you very much, Canva. Super Nothing says, will the trial go ahead without the Supreme Court ruling regarding the not guilty on the first trial? You know, that's a really good question, but I do think that, I mean, she's barreling ahead for an April hearing. So I guess she will go ahead. Is there any chance of getting a new judge in this case? Asked Shiro Sheena. I don't think so. I don't think so. Oh, thank you. Tarm wants to know when my birthday is. Well, I appreciate that. Tree, why a neurologist did you watch the first trial? Why a neurologist? So yes, I watched the first trial. As far as the why a neurologist, I'm not following you. What your question is. Maybe give me a little more detail. Thomas, could it be like the Baldwin case where all evidence was not turned over? Yes, it could be. That's exactly what they're arguing. That is exactly what they're arguing. Now, it's worse than that because in the case that against Alec Baldwin, they had the evidence and they didn't turn it over. Here, the evidence doesn't exist. At least that's what they're arguing. It's not that they withheld it. So I don't know. Maybe you could argue the other one was worse, but that it doesn't exist. It's missing. It's gone. And therefore, they can't have the evidence that they need specifically. So Dolly asking about Natalie Cochran. So my personal view was that it was an unbelievably close case, but that I felt like the government had not quite met its burden of proof. The part that just really affected me was that they were unable to show the insulin shot. There was no proof of the insulin shot. They were unable to do the test or did not do the test when he got to the hospital to show that. They weren't able to determine anything on the autopsy. So I just felt like we were missing a critical piece. Would that have meant she got away with something? Very possibly. So, but the jury, I'm grateful that they had to make that decision because it was a super hard case, in my opinion. Is it normal to be getting so close to trial date with all these motions? Asked Sanjo. 100% it is. It is, in fact, very normal to be doing tons and tons, more and more motions as you get closer to trial. I think the biggest reason is everybody's focused on it. So everybody's, wow, it's a deadline. And so everybody's getting all their stuff in. Irish Amy, if this does go to trial, are the odds worse for the defendant? Just thinking of the Menendez brothers. Are the odds worse for the defendant? Just thinking of the Menendez brothers. Irish Amy, I'm sorry. It's probably because I am so tired tonight, but I don't know exactly what you're asking me. The odds are always bad for the defendant. Oh, I know what you're saying. Because the Menendez brothers had 2 trials and the second one went worse. So it is the case that the prosecution can keep trying it. And let's say it's really close and really close. Eventually, maybe the prosecution wins. It's kind of just a question. If it's really close, then who will actually win first? But I don't know that it's any, I mean, I think maybe a little bit, but I don't think specifically, because I think it's the same issues will be there. And now we'll just see how they play out in a new trial. Witnesses will be prepared. Witnesses will know what was asked last time. It's going to be a different trial. But I don't know that it's necessarily going to be worse for the defendant. I don't think it necessarily will be. All right. Linda asking, when a letter was sent from the court demanding the preservation of phones and data, why did they not require proof of receipt of the letters and signature required? So if normally, at least this is how I've experienced it, if you receive, I don't normally receive a letter from the court saying to preserve evidence. Normally, I would receive a letter from the other side stating that, you know, you must preserve evidence and you have a duty as an attorney to inform your client that they have to preserve this evidence. So that's what I would normally be expecting to get. And so if I got that, then I would document that with a letter to my client to make sure they knew and understood exactly what they needed to preserve. And so the receipt would be, so to speak, would be my letter to the client saying, this is what you have to preserve. I'm not sure if I completely answered your question. I'll just give you my background experience on that. Okay, Tree asking, Brennan stated they were getting a neurologist. I assume an expert witness. Yes, you're right. Okay, I'm sorry. He did say that today. And I don't know exactly what issues they plan to ask for. Maybe it has something to do with at what time what the time of injury was to John O'Keefe, like how long had he been lying in the snow? He was not declared dead until after he got to the hospital. And so I believe they might be looking at that area, that time frame, but we don't have good information about that yet. But that's exactly the kind of thing I'm talking about. It will be a different trial. There will be different issues that will come in. Had they ever found the dog, Chloe? I think there was information about where the dog was rehomed. So I think that it's possible to find the dog. I don't know if that's been chased down, or maybe even if anybody wants that. I mean, who wants that? Maybe the defense might not, because let's say there isn't a match between the marks and Chloe's teeth, then would that disprove the defense theory? And if it would hurt the defense theory, maybe they don't want to chase that down. And I don't know whether the prosecution has any reason to either. If they can come up with some other testimony that would explain what the marks were, something other than a dog bite, then they may not need that either. Yes, Maria Z, seems to be a lot of convictions on circumstantial evidence. Yes, that is true. And maybe part of the reason for that is they're interesting to cover because they're hard and they're mysterious and they're uncertain, and those make for interesting cases, or at least they get me interested in a case. So maybe that's the reason. All right. What is the probability Karen will be convicted of manslaughter this time? Asked Lynn Perdita. Gosh, you're asking an awfully hard question. I should definitely be investing in risky stocks if I could definitely answer that question. But as far as the probability any time for a defendant is that they'll be convicted. This is an unusual case, and she has phenomenal lawyers and presented an incredible case last time. So we'll just see, can it be done again? And if so, can they figure out how to explain to the jury that they can decide one issue, not all of them? They can make choices. They don't have to say, well, we can't resolve everything, therefore we resolve nothing, which is what happened last time. So, all right. Well, I will see you all on Monday at 7 p.m. Eastern, and I look forward to it.